And thank you again for bearing with us while we wait for delegates to log on this morning, as we have so many registered. Welcome to this, the latest in Cornerstone Barristers webinar series on housing law. This one, a housing practitioner's guide to the public sector equality duty. Speaking this morning, as you will see, are Andy Lane, Riccardo Calzavara, and I. Many of you will know us already, but for those who don't, we specialise in public, local government and housing law, and each of us has in recent years been involved in some of the leading cases in that field. We hope that you find this webinar both informative and helpful. Before I move on, and on an entirely different subject, Andy has pressed me not to forget to mention that in this introduction that Manchester United won the Youth Cup yesterday, apparently, and so, and I quote in his words, are back. As he did so much of the work preparing the slides for this webinar, for which Riccardo and I are both grateful, we couldn't possibly refuse or begrudge him that request. Although I think Riccardo and I probably would both observe that it will be nice if at least one Manchester United team has some success this season. I can see Andy grimacing slightly. Without further ado, what will we be covering this morning? Well, I'm going to be taking a look at a broad overview of the public sector equality duty, covering some of its key concepts and basic ideas to give you a fundamental understanding of what the PSED is all about. And then Andy is going to take the second tranche of slides, that is, why is the public sector equality duty important in social housing law, before Riccardo covers compliance, practical aspects of performance of the public sector equality duty, improving the prospects of provable compliance. And then at the end, time permitting, we will take some questions that have been raised during the course of the webinar. We can almost certainly skip the next slide, not least because when compared with my webinar speaking slot, it simply demonstrates how much I've aged since that photo was taken. So by way of an overview, let's start at the very beginning. What does the 2010 Act actually provide? Starting point, obviously, is section 149 of the 2010 Act, by which a public authority must, in the exercise of its functions, have due regard, and pause there to note that expression because we will return to it, have due regard to the need to essentially do three things. First of all, eliminate discrimination, harassment and victimization, and any other conduct that is prohibited by or under the 2010 Act. That's the first. The second, advance equality of opportunity between persons who share a relevant protected characteristic and persons who do not share it, and we'll come back to the concept of protected characteristic very briefly in a moment. And in particular in that regard, to the need to remove or minimize disadvantages suffered by persons who share a protected characteristic that are connected to that characteristic, and then to take steps to meet the needs of persons who share a relevant characteristic that are different from the needs of persons who do not share it, and then thirdly, to encourage persons who share a relevant protected characteristic to participate in public life or in any other activity in which participation by such persons is disproportionately low. So that's the second tranche of obligations, and then the third is to foster good relations. That's due regard to the need to foster good relations between persons who share a relevant protected characteristic and persons who do not share it, and in particular in that regard to the need to tackle prejudice and promote understanding. Now, as you will appreciate, the section relies for its application and its scope, and indeed its effect, on several key concepts. First of all, the concept of public authority. Secondly, the concept of protected characteristic. And thirdly, the concept of due regard. I'm going to focus primarily on the second two of those because I know that Andy will be coming back to the concept of public authority in his slides. Very briefly, by way of an overview on that concept, public authority, you need to look at the definition in section 150, subsection 1, and in schedule 19 to the 2010 Act. So as Andy will tell you later, that certainly includes local authorities. But also by section 149, subsection 2, it includes a person who's not a public authority, but who exercises public functions. And as I say, Andy will be returning to that definition and what it covers in his tranche of slides. So that's the very beginning. That's where we start, section 149. And if we move to the next slide, we can start to look at one of those three concepts, that is the concept of protected characteristic. And there are a number which are protected under the 2010 Act: age, disability, gender reassignment, pregnancy and maternity, race, religion, religious belief, sex, and sexual orientation. And the reason that disability is highlighted there is because the characteristic most frequently raised, encountered, and relied upon in the context of housing litigation is indeed that of disability, whether that's in the context of PSED performance or alleged discrimination under sections 29 or 35 of the 2010 Act. It will be immediately apparent to you that each of us has several characteristics that are protected under the 2010 Act. But for present purposes, we probably need to say little more about protected characteristics, save that, first of all, you should ensure that you are aware of and familiar with all of those that are protected, because any of them could arise in the context of housing practice. And secondly, you should further familiarize yourself, because of the frequency with which disability arises, with the extended definition of disability in section 6 and schedule 1 to the 2010 Act, and in regulations made under it. But for present purposes, by way of an overview, those are the characteristics that are protected under the Act. Moving on then to the third of those concepts, that is the concept of due regard. Now, the concept of due regard is probably, or possibly at least, the most litigated of the three concepts. Like the others, like the concepts of protected characteristic and public authority, it defines and delimits the nature and the scope of the public sector equality duty. But unlike them, it's by far the most nebulous and arguably open to interpretation. As for nature and scope, the expression, in my view at least, is a clear pointer to the fact, as we will see on subsequent slides, that the PSED is a duty about process and not about results, not about outcomes. And it's a key part of the mechanism which ensures that considerations of equality and diversity are factored in to all public authority decision making. But as for nebulousness, the authorities tell us that what amounts to due regard and the scrutiny that it requires will vary from case to case. And I'd encourage you to take a close read of these two cases, that's the Sheikh case and Patrick, because they're very informative and helpful to the housing practitioner. The first of them, a recent case, Court of Appeal Authority, tells us that the concept of due regard is highly sensitive to facts and context, and that how intense the regard must be in any particular case to satisfy the requirements of the PSED will depend on the circumstances of the particular decision-making process in which the duty is engaged. This is taken from paragraph 56 of the judgment, so you can, of course, read it for yourselves. What is due regard in one case, therefore, will not necessarily be due regard in another, and will vary perhaps widely according to circumstances. And it's important that we get our heads around that from the outset. And just skipping down that particular paragraph in the judgment, what is said by the Court of Appeal in that regard is that when the decision comes, for example, at an early stage in a series of decisions and will not fix once and for all the impacts on persons with protected characteristics, the level of assessment required at that stage to qualify as due regard is likely to be less demanding than if the decision is final or permanent. Now, just pausing there for a moment, that might be said to indicate that, for example, in the context of possession proceedings, where you have a preliminary step to bringing proceedings, such as the service of a notice under an ordinary notice seeking possession, arguably at that stage of proceedings, which is not a final decision, the level of scrutiny, the level of due regard may be less than it is when you subsequently decide to seek possession. But quite frankly, to be safe, at any point, you should ensure that your scrutiny of the relevant factors, and Riccardo will come back to some of those, I think, in due course, is rigorous at all stages of the process. And then in Patrick, reaffirming that point, or rather preceding it, that when considering what is due regard, the public sector landlord must weigh the factors relevant to promoting the objects of the section against any material countervailing factors. And in housing cases, they may include, for example, the impact which the disabled person's behaviour, insofar as material to the decision in question, is having upon others. So as I say, I would encourage you to take time to read both of those judgments, along indeed with Forward and Aldwick Housing Group Limited, because they are two of the most instructive authorities for housing practitioners in recent years. So as for purpose and limitations on the duty, and returning to the nature and scope of the PSED, it's important to understand 2 points in particular. First of all, that the public sector equality duty informs the decision-making process and doesn't override it. And that brings us back to the point I was making earlier, that it is a key mechanism by which considerations of equality and diversity are factored into the decision-making process, but do not dictate a particular outcome. And in a similar vein, that the duty is one of consideration, one of due regard to the various factors that we looked at in section 149, and it's not one to achieve a particular result. And as I say, if you read the judgment in Patrick, you will see that proposition reinforced. So, picking up on the weighting of competing considerations and what is essentially the supervisory role of the courts in ensuring compliance with the PSED, we've summarised for you here on this slide some of the key points that are taken from recent authorities. And so, as we saw a couple of slides ago, what is required by section 149 will inevitably vary according to the circumstances of the case. And as you'll see, given that the authority for that proposition there is the case of Hotak and Southwark, that is a point that has been repeated and reinforced in different authorities over the years. And frankly, you don't get much higher than the Supreme Court judgment of Lord Neuberger. And then consideration as to the enforcement of the PSE does not extend to the question of how much weight to give to the duty or what weight should be given to the equality implications of a decision or action. They're matters which fall outside of the PSED because PSED, as I indicated earlier, is a process duty, and matters of weight, that is the weight to be attached, to be given to each of the countervailing factors in a particular case, is purely a matter, in the first instance at least, for the public authority that is making the decision. And as Lord Neuberger indicated in Hotak at paragraph 75, citing the judgment of Lord Justice Elias in Hurley, it's for the decision maker to determine how much weight to give to the duty. The court simply has to be satisfied that there's been rigorous consideration of the duty. And he continued in that same paragraph that provided there has been proper and conscientious focus on the statutory criteria, then the court cannot interfere simply because it would have given greater weight to the equality implications of the decision. So it is for the public authority to decide in each case what weight to attach, and provided it really scrutinises its performance of that duty and the various factors properly, the court will not intervene just because it thinks that a different amount of weight should have been afforded to different factors. So these dicta may then provide you as housing practitioners with a degree of solace, given that it's your job essentially to ensure compliance with the duty at public authority level. And as this slide indicates, context is clearly very important, as we saw in a previous slide. So one final word on that, taken from a different authority, on context and the point that the requirements of the duty will vary according to circumstances. And this one's actually taken from Powell in 2019 in the judgment of Lord Justice McComb. So one must be careful not to read the judgments, including the judgment of Bracking, one of the leading authorities on the PSED, as though they were statutes. So, for example, the decision of a minister on a matter of national policy will engage inevitably very different considerations from that of a local authority considering whether or not to take a particular step in ongoing proceedings to recover possession of a unit of social housing. So context, facts, circumstances are key, and they will determine not just the level of due regard that needs to be had to the PSED and its various factors in a given case, but therefore, as a consequence, the real scope of the duty and how it should be complied with. So summing up some of those concepts, some of those ideas, and you'll find a very recent and helpful analysis of them in the Sheikh judgment to which I referred previously. So section 149 does not require or dictate a particular result or outcome. It is a duty about process, about the decision-making process, and ensuring that the requirements, the three requirements that we looked at in section 149, are each taken into account when any public authority decision is made. So it doesn't prescribe a particular procedure, such as the production of an equality impact assessment, but it does imply a duty of reasonable inquiry. So where a public authority, for example, in a possession case concerning disability, either knows that there is a disability or reasonably to know that there is a protected characteristic involved in the case, there may be implied a duty to make further inquiry about that protected characteristic. It obviously requires the decision maker to understand the equality impacts of the decision before, for example, adopting a policy. As far as the supervisory role of the courts is concerned, they should not engage in an unduly legalistic investigation of the way in which an authority has assessed the impact of decision on equality needs. That brings us back to the point that the weight to be attached to any particular countervailing factors is, in the first instance at least, and provided the authority does its job properly, will always be a matter for that public authority alone. Now, before I hand over to Andy, who I can see is itching to start speaking, let me take you back to the judgment in Patrick for a moment. And I don't have a slide on this, but I'd just like to make a number of points and reinforce to you the real need to read that judgment carefully. Because at paragraph 42, in a very helpful judgment, Mr. Justice Turner, provides a very helpful summary of both the scope of the duty and the obligations that it imposes in possession claims, for example, possession claims against the disabled. And it makes 9 key points, and I'll summarize them briefly because I can see that my time is coming to an end. So number 1, as we've seen, the PSED does not imply or impose a duty to achieve a result, but to have due regard to the need to achieve the results that are identified in section 149. Secondly, it imposes a duty to make further inquiry if there's a real possibility of a protected characteristic, for example, disability, being in play. Thirdly, it's a duty of substance and not form, and therefore it must be performed with rigor and with an open mind. It's not a tick box duty that is a matter of mere formality. It's an ongoing duty, but should be considered when an order is sought, and only later if there's been a material change of circumstances. Although in that regard, you might also take a look at the Paragon and Neville judgment at 2018 HLR 39. Fifthly, it arises if the landlord knows or ought to have known of a disability. 6, recording the steps, and this is something to which Riccardo will return. Recording the steps taken in compliance with a duty will almost certainly assist evidentially when you as a public authority are required to prove your compliance with it in subsequent litigation. 7th, the conscientious decision maker, and this comes from the decision in Hotak, focusing on the impact of a disability may comply with the public sector equality duty, even if they're unaware of its existence as a duty in the first place, or indeed of the terms of section 149. And I think this is a point to which either Andy or Riccardo will return in due course. 8th, the court's role, supervisory role essentially is to be satisfied the landlord has carried out a sufficiently rigorous consideration of the duty, and weight is really a matter for the landlord and not for the court. And then lastly, ninth but not least, the decision maker must be clear precisely what the equality implications are when they're put in the balance, and so must recognize the desirability of achieving them. But as I say, ultimately it's for the decision maker to decide what weight should be given to each of the factors in light of them generally and the circumstances of each case. I've exceeded my time limit by 2 minutes. Andy's been very patient. So without further ado, let me hand over to Andy, and he's going to take you now through the second tranche of slides.
Thank you very much, Dean. An invaluable start to looking at the various issues that I'm addressing, which is the relevance of the public sector equality duty to social housing law. My next slides will be looking in particular at the impact and the extent of that impact that it's had and is likely to have in the coming months and years based on the case law. And as Dean has quite rightly said, although there's a lot of authorities on this, and it's still a common issue that is raised in homelessness, in possession work, in allocation work, etc., there are a few cases which are particularly important to read, such as Patrick, such as Shake, such as Ford and Aldwick. So that is very important to look at. And I also just ought to say apologies to Riccardo if I step on his toes in terms of dealing with any of his stuff. We'll pretend that I didn't say it if that happens. So looking at the role in social housing cases, where do we actually encounter the public sector equality duty? Well, we know, of course, that in judicial reviews, it's very common. It's almost invariably going to be raised in a challenge to a local authority's allocation policy, albeit probably as part of a wider range of grounds, such as indirect discrimination. And we saw that, of course, in cases like Neuro and Birmingham, Zed and Hackney, Gulu and Hillingdon. It's going to be raised, of course, in any homelessness challenges, and we've seen just, I think it was last week, the cases of El Kundi and Imam being dealt with by the Court of Appeal with their imaginative ideas and dealing with the question of how to deal with homelessness where the local authority is struggling to comply with the Section 193 duty. And of course, the public sector equality duty was raised, although didn't play a big part. It's often seen in homelessness Section 202 review decisions, because obviously if you're looking at priority need on the basis of vulnerability, if you're looking at suitability of accommodation, where one may be addressing disability issues, etc., then of course it's going to be engaged. And of course we have got, as Dean has mentioned, Lord Neuberger's judgment in Hotak, which very much gives us a great guide as to how that's dealt with. And it's also fair to say that in terms of compliance, Hotak also made it clear that one can comply, of course, without knowing about the duty. Now, it has been said, and I think it was said in Dodana, that's going to be rare, although as we'll see from, I think, my last slide, how rare that is a debatable point. But what that effectively means is you may have a very effective housing officer or homelessness review officer who is very much focused on the person's, for example, disability, very much focused on their needs, very much focused on what would happen if they weren't assisted by the authority, and yet don't address it with the knowledge of Section 149, 1A, 1B or 1C, but is still treated as having the requisite focus to mean that there's compliance. And of course, it's often dealt with in the question of possession work. Now, my normal commentary is it's badly pleaded because it's often a line in a defence. But ironically, what often happens is it's all that's left when one goes through the appeal system. And just to give two examples of that, Dean has already mentioned Powell and Decorum, in which Rucci and myself were involved. That was just part of a application to stay execution of a warrant, where of course there were issues as to factual matters. Has there been a breach of the suspended possession order, as well as discrimination? And the PSED came along some way behind, but became the only issue that was left at the end. Same, of course, with a case I'll be very briefly dealing with at the end, the more recent case of TM and Metropolitan, where again, issues of reasonableness, issues of breach, issues of discrimination were all dealt with and indeed upheld, but the public sector equality duty was the thing that effectively meant that the claim for possession ultimately didn't succeed. One of the rare instances, having said in that slide that it rarely succeeds as a standalone ground, it's one of the rare instances where it did. As I say, I'll be dealing with that in the last case. So it's often going to be there in housing cases of all kinds of descriptions. And therefore, when one looks as to when it needs to be complied with, which is the next slide, it's clearly going to be relevant to when you're making a decision. If you're a public body or if you're exercising a public function, which I'll come on to shortly, you're going to be making lots of decisions to do with housing law. And I've given you 5 examples there. And as Dean has indicated, the kind of the rigor with which you apply your consideration of the public sector equality duty may vary depending upon when you're issuing a notice seeking possession, for example, or even when you're issuing a notice to quit, which could end the tenancy and therefore has more impact. But the difference between the notice seeking possession and the issuing of possession proceedings. So it does depend a little bit as to exactly what stage you're at. But it goes through the whole gamut of a public authority's decision making. It, of course, deals with the whole question of a housing association if they're exercising a public function and their decisions as to whether to allow a mutual exchange, as to whether to seek possession, as to whether to apply for an injunction. So clearly it needs to be complied with at those moments. So when making a decision, effectively it needs to be complied with. Therefore it's quite clear that the need to achieve those goals that Dean has read out in section 149, 1A, B and C have to be very much in mind when one's adopting any approach to injunctions, possession works, allocation, mutual exchange, etc. In terms of saying, as Dean has indicated, who does it apply for? I think most of us these days just take a fairly relaxed view. I mean, sometimes in pleadings, one may have the approach of, for the purposes of this matter at first instance, it's not disputed that the association is exercising a public function. But the reality is that certainly with local authorities, virtually all their decision making is going to be directly a public law decision. It's provided for in the Human Rights Act as such. It's very clear that they are invariably going to be a public law decision. Whether a housing association, which isn't, of course, a public authority, is exercising a public function, which is the other route by which you may still be required to comply with the public sector equality duty, one may argue is a moot point, but we know from Weaver, which is the well-known case, albeit based on certain concessions as to the fact that it was a hybrid authority, that it's generally accepted that in most instances, most of the functions of a housing association are likely to be seen as exercising a public function. Particularly, of course, if you've got an association which has taken over from a local authority stock, you've got a local authority which is assisting the local authority in its homelessness functions, you've got a local authority which is receiving money from the government for certain projects, you've got a housing association doing that, or you've got a housing association which is offering low rents. It's often seen as exercising a public function. And it certainly was in McIntyre and the Gentoo Group, although McIntyre lost for other reasons, there was an alternative remedy. But John Howe QC, sitting as a Deputy High Court judge, took the view that, yes, it was exercising a public function in deciding whether there should be a mutual exchange stroke assignment or not. Of course, it does go the other way at times, and MacLeod and Peabody Trust is a good example where, for a very similar issue of mutual exchange assignment, it was decided that Peabody Trust weren't exercising a public function and therefore weren't susceptible to judicial review, and obviously by implication weren't susceptible to the public sector equality duty on that particular issue. But a lot of that was to do with the question of where its funds came from for the particular project. If your funds are not coming from central government, if funds are not coming from grants, but are, as it was in this case, coming from the open market, it's arguable, of course, that you're not exercising a public functions. And of course, there are some housing associations which are for-profit bodies, and therefore there's an argument that those won't be covered in such circumstances. So the reality is that most instances we're going to find they are going to be covered. There was some reference in one of the questions we got in advance as to what about a housing association which has a private rent team. Well, all I would say is merely calling something private doesn't make it private, doesn't make it not exercising a public function. Housing associations are, after all, offering private tenancies. That's what it is. It's a Housing Act tenancy in the vast majority of instances. You have to look at who is funding that, how it's funded, what its object is, etc. So the mere title of a private sector team may not be sufficient to mean that it's not a public function. Looking at the question then of saying, okay, well, we're covered by the public sector duty. We know it's a kind of issue that we have to consider. What's the impact of it? And I cited there from Lord Justice Patton, who's been involved in many of these cases, as one might expect, as to the impact. And this is the case of Luton Community Housing Trust and Dodana, which some of you will remember is a Ground 17 case, a false representation to obtain a tenancy case, where regrettably the daughter of the tenant had cerebral palsy, I think, and the tenant herself had PTSD. And it was decided that there had been an equality impact analysis done, which is quite common these days, but that it had been done really for the purposes of proportionality. And remember, proportionality is to do with discrimination. Arguably, it's to do with Article 8 as well on the convention rights, but it's not to do with the public sector equality duty. So that equality impact analysis, according to Judge Bloom, was not sufficient to deal with the public sector equality duty. She found that the public sector equality duty had been breached, and she found that it wasn't inevitable that it would be the same decision made. In other words, even if you breach a PSED, if it's highly likely the same decision would be made again if you did comply with it, then of course it doesn't have any impact on the course taken by the public authority or social landlord. And she didn't go on to consider reasonableness, having reached that conclusion, and dismissed the claim for possession. What the Court of Appeal effectively said in that case was, well, she was certainly right that there had been a breach, and she's certainly right in respect of that. However, despite the serious position of the mother and the daughter, there had been an effective consideration of the impact of eviction, for example, on them, and that the proper test was not inevitable. In other words, it's not inevitable that the same decision would be made, but highly likely, and that therefore they allowed the appeal and sent it back to the county court for the question of reasonableness to be considered, which, remember, hadn't been considered at all. So when one's looking at impact, I think what one can say is that really it can inform a reasonableness assessment if you're dealing with a discretionary question, such as an injunction, such as a Schedule 2 ground for possession claim issued by the local authority or a housing association. Although it's not true to say that a breach of the PSED will inevitably lead to the failure of the claim, one has to look at what the impact of that breach is. It may be that you can prove that there's no discrimination, but the breach is a serious breach, it's a serious duty. But would it make any difference? Is it highly likely that if you did exercise the consideration of these matters, the same decision would have been reached anyway? And if that is the case, then it wouldn't have any impact. And invariably, as I say, it's not a standalone defence, and is often considered in the round with a number of other matters. So in terms of the impact, it can have an impact, but as I say, it rarely is the defining issue. Now, looking at some public sector equality duty cases involving housing, you'll be glad to hear, and certainly Dean and Riccardo will be glad to hear, I'm not just going to go through that list. I mean, it's really there to show there has been a lot. And you might have thought, and I remember a friend and colleague of mine wrote an article saying, you know, is that the end of the PSED after one of those cases? I can't remember which one it was. And I think the answer has always been no. It's a very important duty and has to be complied with, even though it often doesn't have a great success rate if you're the defendant. But what these matters show is that it is still being raised, it is still being dealt with. And so, for example, in possession claims, I'll come on to TM and Metropolitan, but Taylor and Slough was a case to do with a closure order and then an absolute ground being pursued, and the court finding that no, there'd been adequate consideration. And the judge was entitled to find compliance with the public sector equality duty, and the complaint about it was a rather arid and technical opposition to exactly how it had been dealt with, but certainly the officer had properly considered these matters. Homelessness, as I say, particularly dealing with questions like priority need, and which was a McMahon matter, and suitability, it's often going to come up. But of course, you are focusing on the person's vulnerability, and so often you're considering it in any event. And I just have cited from Lewison's judgment at paragraph 89, he said that there's a real danger of the public sector equality duty being used as a peg on which to hang a highly technical argument on an otherwise unimpeachable vulnerability assessment. So one has to be careful that one doesn't, for example, look necessarily at Macomb in Bracken, but one looks at Macomb in Powell, because one's looking at the right context to fit in. It's not there to set technical traps, he went on to say. It's not a disciplinary stick in which to beat the review officer. So one has to be pragmatic. Did it have an effect on the approach of the review officer and on the decision? If it did, fair enough, the review will be discharged. If it didn't, then of course the appeal will fail. Biden was also a suitability question. Public sector equality duty of one of the grounds, but again, there was a finding that sharp focus was given to Biden's circumstances, and therefore it was dismissed. There was a question of LGBT questions and whether the officer had approached the right people, but the finding of the court was that was sufficiently done, and there was no reason to find that the people they did consult with weren't the right people to consult with. Very briefly, allocation policies, as I indicated at the start, is going to be a very common challenge as part of the challenge. We saw that in the Supreme Court in Zed and Hackney, and we've seen it more recently, as I mentioned earlier, in Muir and Birmingham City Council. Hertfordshire and Davis was merely an application, but shows that it can be raised even in applications. That was the challenge to the issuing of a warrant following the making of a possession order, and as a public sector equality duty as to how that had been given permission to be issued, and so it can arise in applications as well as in final hearings. So it's a common feature that one finds in these matters. The one has them. Whilst on this page, can I just very briefly mention 2 points arising from questions again asked in advance? One talked about any difference in approach to non-secure tenancies. Well, I think the answer to that must be no. They're still tenancies. They don't in themselves require a different approach. You still have to consider them. And if you're being offered an unsecure tenancy because of a homelessness requirement, which of course is the usual reason why you are in unsecure tenancy accommodation, then there's all the more reason in many instances why you do need to consider the person's circumstances. So it shouldn't make any difference. In terms of the question there was as to whether if you had a forfeiture case, whether that's to do with flexible tenancies or whether that's to do with long leases, does that in some way indicate that you're reinstating the tenancy because you're considering the public sector equality duty? Well, it has no bearing on that. What you're considering is your actions, your decision to take proceedings. You're considered to make the application for a declaration of breach. It doesn't have any impact on, for example, you treating the tenancy as continuing or you granting a fresh tenancy. In the final 2 slides, I just wanted to raise the question of TM and Metropolitan because people get very excited at times by these decisions, and it was a interesting case with some excellent counsel in and myself. Karen Monaghan and Nick Bano, very talented and very impressive people for TM, and I was privileged to work with Liam Varnum at Fenders Chambers for Metropolitan. But it has to be seen in its context, because remember, in this case, this was a case where, unfortunately, TM is a paranoid schizophrenic in supported accommodation where there had been instances of violence and aggressive behaviour, and there had been a finding that there had been a valid notice, a breach of the grounds for possession set out in Schedule 2, that it was reasonable to make an order, and that it wasn't discrimination, indirect or disability discrimination, to proceed with possession. The only question is that, and there had indeed been compliance with the public sector equality duty up to the point and following the issue of proceedings. The only query was when a report came after the issue of proceedings as to capacity, should there have been another review? And effectively, the Court of Appeal said yes, there really should have been another review. And the attempt by Metropolitan, who had an excellent officer, one of the best officers I've come against, but the attempt by them to rely on the cross-examination and his response to cross-examination questions was not sufficient. It wasn't giving that conscientious and open inquiry that's required, and therefore it wasn't sufficient. A frustrating case, and interestingly, and highly likely, because one might take the view, having succeeded on reasonableness and discrimination, etc., it was highly likely it would be the same. What they said was, well, because the officer himself said he might have done something different, it's not highly likely. So they looked at it from the prism of the individual officer in the individual case, not from the prism of the trust. And in a sense, it's fairly obvious what the trust would have done because they were continuing with the proceedings. But the court were focusing on the individual officer and what he'd said in cross-examination. And finally, and a lot of this is just really re-emphasizing what Dean has done in his opening. It's really saying that, of course, a breach may not be fatal because one's looking at the question of highly likely, a question that was dealt with in Aldwick, followed in Dodana. Context is crucial. I always find it very frustrating when one gets skeleton arguments from opponents who kind of go on and on about bracking, which is a fascinating case, but nothing to do with my decision as an officer, for example, to take or make an application for permission to issue a warrant of possession. It's a totally different context, totally different idea. Lack of knowledge of section 149 may not be fatal. We saw that, as I say, in Hotak, and we also saw in McMahon, and you've got the citation there, that he didn't really want to be drawn Lewison into the debate between whether it's only rare, would that be the case or not. But what effectively he was saying, it's contextual. If the officer has in fact dealt with the issues of disability, dealt with what would be the consequences if assistance wasn't provided, or if the possession order was made, or if the injunction order was made, or if the mutual exchange wasn't given, then it may well be that that still satisfied and satisfies the question. And in a sense, most importantly, as Turner said in London and Quadrant, Housing Trust and Patrick, but had previously been said by Elias, it is not a duty to achieve a particular result. Now, and therefore you've got to be careful if one is challenging it, but one has to be careful not to say, well, if you had have considered it, you wouldn't have done this, because that is a matter for the public authority or the authority exercising a public function. And that's the important question there. And the question of weight is a matter for the decision maker, not for the court and not for your opponent. It is what I would say in summary, best of course to expressly consider the duty. It's best of course for people to know about the duty and to know about section 149 and to have internal training to that end. It is still very much an issue in housing across all aspects of housing. And it's important because it can be an effective opposition to a possession claim. It can be an effective opposition to an injunction order. It can overturn a policy if one's been done. And most importantly, before passing on to Riccardo, it is an ongoing duty. And I've mentioned that in TM and Metropolitan, they had complied up until the issue of a report about his capacity, but not after that. And Dean and I were both involved just before we joined our current chambers with Decorum and Sims, where there was a constant review of Mr. Sims's condition and a really effective review by Decorum to make sure that they were on top of it. And they really did consider it every step of the way. Here's some more information. Okay, we'll consider that. No, we still want to continue with the proceedings. So it's an ongoing duty and isn't just a once and for all. So on that rapid run through, undoubtedly overrun, I will pass to Riccardo.
Thanks, Andy. As Dean said in opening, I'm dealing with the practice, with the practical consequences. So the question for me is, how does a public authority comply with and evidence compliance with the PSED, remembering that it's a duty to have due regard? Let's start from the ground up. Having appropriate and considered policies in place shows that the authority has considered in advance the sort of issue that might arise and the particular circumstances pertaining in its district. And it also makes it easier for officers to know what they should be thinking about and helps ensure consistency in decision making. Those policies will probably refer to the carrying out of equality impact assessments, sometimes also colloquially called proportionality assessments, although, as Andy has said, those are different things. Those assessments might not be essential, as Andy said on the slide, but in my experience, they're a valuable tool for, again, forcing rigorous and considered compliance with the PSED and for evidencing that there has been that compliance. And for that reason, their importance is not to be underestimated. In some cases, as Andy's just said, it will be necessary to consider the PSED and carry out an impact assessment on a number of occasions. So let's imagine for a moment a possession claim. The authority might want to consider the PSED on being informed of whatever concern arises before serving notice, on receipt of any representations, when bringing the claim, after the claim is defended, at the evidence gathering stage, and in some cases, even once the oral evidence has been heard. And the third bullet point I've got is internal data. It's surprising how often it's asserted that not just another arm of the authority has some relevant information, but that the same arm has it. So, for example, you'll often have an assertion in the particulars of claim that there are no known disabilities when the tenancy application form lists a whole range of mental and physical health problems. It's important to get on top of this information as early as possible, not least because in some cases it might affect the decision whether to bring any claim in the first place, exposing the authority to needless costs risk. And finally, there'll be numerous third parties with whom the tenant, if we're continuing the possession theme, will or may have had contact. In the homelessness context, authorities are used to carrying out this sort of information gathering exercise, but in my experience, less so in the possession context. Any attempts that have been made to contact the GP, mental health services, social workers, or the police will satisfy the twin aims of permitting compliance and evidencing it. Speaking of evidencing it, can I have the next slide, please? This is a passage from TM. We just heard Andy discussing it. I'm not going to read it out. You've got it there on the slide. There are 2 points to take from it. First, that evidence will be invaluable in proving substantive compliance with the PSED. And second, and perhaps more importantly, that merely going through the motions is not enough. The court wants and will look for a conscientious inquiry, not a tick box exercise. So this is the difference in practice between saying, I looked at it and it doesn't alter my decision, and instead saying, I looked at it and it doesn't alter my decision because. Can I have my next slide, please? It's useful to look in more detail at the policy question because, as I've said, it's best to build from the ground up, and it's in the policies that everything begins. These policies obviously can't address every possible circumstance, but that's not their purpose. Their purpose is to give a skeleton, or if you like, a background against which individual cases can then be assessed. But that will require some considerable detail because there are myriad possibilities, I suppose not quite infinite, that might arise. So you can expect an authority's relevant policies to be lengthy and substantial. Their purpose is to set out the principles that might arise. We have some examples here on the slide. They'll invariably require that the decision maker is aware of the public sector equality duty, particularly by reference to it and what it requires. That will make it simpler for the decision maker to show her awareness where she's referred to such a policy. We have the remarks that Andy and Dean have taken us to and alluded to in Hotak, in Dodana, in McMahon, about how an officer may comply with the PSED without knowing that it exists. I must say, I've always taken that to mean that it's not necessary to refer to it, rather than as saying that officers who don't, that there might be officers who don't know that the PSED exists. We've just heard Andy discuss this. And personally, it's been years since I met a decision maker who didn't know what the authority's PSED was and what it required her to do. Remember, we're talking about the Equality Act 2010, it's 2022. The policy should make it clear that the decision maker should properly, conscientiously, rigorously, and open-mindedly focus on the statutory criteria, how they apply in the relevant case, and what their consequence is. So often, the criticism is that mere lip service has been paid to the duty, or that the decision maker had made up her mind before considering the tenant's circumstances. The policy should, as I've said, provide for the various steps of compliance to be recorded in order to satisfy those twin aims: compliance, evidence of compliance. Let me put that another way. The PSED must be complied with and must be seen to be complied with. The policy should also make it clear that it's a continuing duty in the manner discussed earlier on in the webinar. It's not enough, as I've said, just to tick a box prior to bringing a claim. There are numerous events in the currency of a claim in which the duty must be considered afresh. I've listed what some of them might be already. In an extreme case, what started as a claim to which the PSED had little relevance could become one in respect of which the authority must withdraw. Now, I repeat, that's an extreme case, but it is possible, it is feasible. The policy should also make it clear that the duty is non-delegable. The decision maker can't rely on third parties to make her decision for her, whether that be by her lawyers, which was a question I saw we were asked in advance, or by medical professionals or some other service provider. The point of this is that the duty should be complied with by the authority. I should say that doesn't mean that solicitors can't be asked for guidance on compliance with the PSED, just that it should not be left to them to come to a conclusion on it. And finally, so said Bracking, the PSED should be complied with in advance, although we've seen since in such cases as Forward that failure to comply in advance isn't necessarily fatal, and that late compliance will often suffice. And can I have my next slide, please? It just remains for me to summarize, and then we'll address some questions in the hope that we have some time. I see that Dean is studiously typing away. The 7 summaries. 1, it's vital that a tenant's difficulties are known and taken into consideration, particularly those that are known to the authority or would be known to the authority if only it would look at its files. 2, there will almost always be an alternative to the proposed route. Consider it, even if you ultimately dismiss it, because it shows consideration. 3, third parties will often have a wealth of knowledge which will inform the relevant questions the authority must consider, and will in particular make it clear that the decision maker knows what she has to consider and that she has tried to obtain all the relevant information in order to consider it. 4, if there are policies in place, which there should be, it's easy to score an own goal without considering and applying them. So it's vital to be aware of the policies and apply them to the facts of each case. 5, as I've said probably 6 times now, it's not enough to comply silently. Evidence of compliance is key. The PSED must be done and be seen to be done. 6, if circumstances change, it's important to re-review, because the outcome of any PSED assessment might differ in light of newly obtained information. And 7, don't panic, as Andy's put it, or in my own words, this is difficult, but it's manageable, and it's better to try or seek help than to bury one's head in the sand. And with that, and 2 minutes to spare, I think we're on questions. I'll give back to Dean in order to work out how we're going to deal with those.
Thank you, Riccardo. In fact, we've been receiving a number of questions through the course of the webinar, and as Riccardo pointed out, I've been hastily typing away. In fact, I'm just going to hit send on one of them, and I know that Andy's also been doing the same during the course of mine and Riccardo's segments. So you'll find answers to those questions on the chat function in the webinar, and the most latest of them is in respect of compliance. Does that have to be pleaded? And if so, how much detail is required in pleadings and or witness statements? And I think this is a point that Andy referred to earlier, that certainly where, and this is what I've said in the chat function, certainly where the PSED is raised by way of a defence in possession proceedings, for example, you would ordinarily assert compliance and plead compliance and details of it in the reply to any such defence. And then you'd certainly have to evidence that in witness statements, which would usually exhibit the evidence of compliance by way of completion of a report on the equality assessment with any witness statements. The more detail you can provide about that, in my view, the better.
And of course, Dean, in a homelessness scenario, we know from PSED that it doesn't have to be raised by the applicant or their advisors in going through the review process, and it's a perfectly valid, on the facts, of course, perfectly valid ground of appeal. And you can't argue the normal ground, which you would argue, which is the Cramp and Hastings grounds, that if you don't raise it, you can't complain if it's not in the letter. So it ought to be considered in any event, whether raised or not, by a review officer, and indeed by the original decision maker in homelessness.
Yeah, and just before I forget, in fact, and I think Andy's mentioned this on the chat function, if I slipped when I was talking about protected characteristics and I referred to section 169 rather than 149, that was a slip only. Of course, it was supposed to be a reference to 149.
I think that's my slip, because I put it on the top of the slide, so that's my mistake. Oh. We have got a question from Claire. Oh yeah, I think it's to do with that question of local authority housing companies, where there's been a couple of questions which I think Norman had asked, and Claire is also talking about, and whether local authority housing companies are covered by the public sector quality duty. The question of whether they're considered to be a private company is relevant, of course, in some respects, because of course that's relevant to the question of what types of tenancies you're being granted. But as I say, housing associations are often exercising a public function, yet they're granting housing at 88 tenancies. And of course, they are private registered providers of social housing, despite the government trying to push through right to buy for them. So I don't think that the fact that they're private is necessarily the complete answer. I think you have to look at, what it is that they're doing, who are they aimed at, and in those circumstances, for example, what are the rent levels being provided? If they're being, for example, used towards assist those people who are going through the homelessness system, then of course it's more likely to be, treated as a public sector equality duty. And although, of course, local authorities are defined as a local authority as being covered by the Equality Act, public law duties, and indeed the Human Rights Act, of course, you also have to accept that there may be certain functions of a local authority, if they're certainly engaged in private sector involvement, where they could argue that they're outside it. But I think it's a question of what the purpose is. And somebody's just said that it mainly delivers private homes for sale in the open market. Well, of course, in those circumstances, you have a much better argument to say it's not covered. But in circumstances where really what you're doing is you're trying to avoid the right to buy and the diminishing of your stock, it may be that that's not the purpose and that's not being offered. So it rather depends on the purpose of the private housing company.
Yeah, I'd entirely agree with that. And I can see, looking at the chat function, that our friend and colleague Harriet has raised a question as to whether there's any law on when a mental health issue becomes a disability. Is it a question of judgment for the authority or a question of law, bearing in mind the definition? And I think the second part of that question really hits the nail on the head, Harriet. To my mind, in every case, it will be a question of measuring evidence of the disability against the statutory definition of disability in Section 6 and Schedule 1 to the 2010 Act, and indeed the regulations made under it. And let's not forget, as we were indicating earlier in the webinar, that where a question of disability arises, for example, because of mental health, then that may well put the public authority on a duty of inquiry to explore to what extent that disability affects the person involved, and indeed whether it does amount to a disability for the purposes of the 2010 Act. So I think, Harriet, there you've hit the nail on the head.
It's also fair to say, of course, that you can, and it happens a lot with homelessness, but it can be true of possession work and injunction work and other areas as well. You can either not determine whether there's a disability or not, or even if you're wrong on whether there's technically a disability, the important thing is what did you do with the information? And as Dean has indicated, if you know that somebody has an issue, a medical issue, you could still rigorously consider what their circumstances are and how they'd be impacted upon if you took the action that you're proposing to take or not take. And in those circumstances, you may still comply with the public sector equality duty, even if there's a genuine argument as to whether you're right as to the disability question. That may obviously come into the discrimination argument, if there is a discrimination argument. But even there, of course, that's just one part of the argument. And again, you might be right on the question of proportionality if that's available to you. So it is a difficult issue. Well, anything else?
Yeah, I was just about to say I can't see any further questions in the chat function. And so with that in mind, I see some very kind feedback. Thank you very much for that. Unless there are any further questions, and either Riccardo or Andy has anything further to add, I suggest we bring a close to this latest webinar, and we would warmly invite you to look out for future webinars. I'm sure there will be more coming up shortly by Cornerstone Barristers, and we look forward to seeing you back at one very soon indeed.
It may be worth saying that lots of people have asked whether they can have a recording of this webinar. I think our usual practice is that it will be uploaded to our website in due course with the slides. I've just seen someone ask about a copy of the slides.
And it's fair to say, if you look at our YouTube account, it will be there probably tomorrow, if not later today, as are the previous ones. And the only other thing I would say is that remember that we are this year, for the first time, I think in 3 years, having our housing day in person. And I can't remember the date, but it's in October. And keep an eye out for when we announce the programme, but that will be in person in Gray's Inn in October.
Brilliant. Thank you very much, everybody. And again, on my part and Riccardo's, to Andy, thank you very much for all the hard work that went into the slides for this, which is greatly appreciated.
Absolutely.
Thank you very much, everyone.